from Belknap District 8, the communities of Alton, Barnstead, and Gilmanton. I'm here before you today to present HB 1397, establishing a study committee on the Department of Education operating within its statutory authority. Many constituents have contacted me regarding several recent concerns with the New Hampshire DOE. The major theme of these concerns seems to be the lack of legislative oversight, with many new statutes being implemented within the DOE. Indeed, many recent changes within the DOE have gone under the radar, neither coming before this legislature or being openly offered to the public, who is currently looking for answers. Of special concern is whether the DOE eliminated the Division of Educational Improvement that was established under RSA 21:N:6 and replaced it with the Division of Instruction by exercising authority not granted by this general court. In addition, there is a statutory authority for the Division of Instruction to oversee 5 regional professional development centers. One has great difficulty trying to locate how the Division of Instruction came into being. Certainly, it has lacked transparency, and because of this, proper oversight. It seems the Division of Instruction is commissioned to provide implementation of Common Core, but without New Hampshire School Board's authorization. We believe that this is in direct conflict with the established governance of school districts as authorized by the General Court in RSA 193-E. Indeed, many constituents have expressed much concern as meetings at these regional centers seem to have no records or minutes of the meeting, and nothing is available to the public as subject to RSA 91-A. With our state trying to implement a huge federal program known as Common Core and its subsequent Smarter Balance assessments, and its subsequent assessments, it is believed the Department of Ed has hired, quote, regional liaisons to implement Common Core with superintendents and principals, but without the knowledge and consent of our school boards districts. And once again, we see these meetings do not maintain records or minutes for public review. I personally have much unease with any bureaucratic administration meeting under the radar without public hearings or input. I have even heard a New Hampshire state senator sitting at a BOE board meeting tell those board directors to bypass the legislative process and vote to effectively put into statute, undercutting the input and the vote of the people. This is not what our constituents deserve. But fortunately, we have a very informed citizenry here in New Hampshire, and they are ready and will speak to you to bring this topic to the forefront. Some of these people who will testify before you today have years and years of experience, well beyond my 1.5 year endeavor here as a freshman legislator. And they will tell you about what's been happening with legislative and administrative exploits of the DOE for many years. New Hampshire citizens deserve proper transparency and accountability from their public officials. It is hoped that this study committee will be able to offer clarity and bring to this discussion much needed fact-finding answers with regard to DOE overreach. As legislators, we are here to serve our constituents, not the bureaucracy that is inherent within our state government. We are their voice, and New Hampshire citizens deserve to have concise and open answers to these questions and more. I ask for your support with HB 1397. I thank you for your time.
Thank you very much, Representative. Do you have written testimony for the committee?
You know what? I have a little scribble on here, but I could leave that. Should I redo it?
No, just hand me like that, it's fine.
Hey, that's fine then. My name isn't even on it, but I'm sure you can put it on there.
I can take care of that.
Thank you. Yes.
Representative Brennan
Thank you, Madam
has a
Chair,
question.
and thank you for taking my question. You mentioned the implementation of Common Core and how that was done and excluded, I guess, the implication of local boards. Can you, or do you have any way of comparing how that was done relative to how No Child Left Behind was implemented in the state? Was, in other words, was the process of involvement with local boards and what was done by the Department of Education any different when No Child Left Behind was implemented than with Common Core?
Okay, thank you for the question. I'm going to tell you honestly, I was not paying attention with No Child Left Behind was happening. My purview has been fairly recent with Common Core being instituted in our state. And just to speak maybe where you're going with this, I think many school boards signed on to Common Core because the DOE pretty much pervasively said this is a great program and didn't go deeply into the districts to discuss what that meant. These districts signed on. I know my community of Alton signed on to Common Core without fully understanding what it was, just because it's very easy for our boards to be told this is the expert thing to do, this is good for the children, it's good for everybody. The process was not transparent. And we woke up in July, in a summer when school wasn't meeting, to find out that Alton had signed on to Common Core. This kind of thing, this kind of overreach, although sometimes it doesn't get addressed because it can be a conflict, right? This kind of thing is what this committee will make clear. How did that happen? How is it that it didn't come through our school districts? And I can name numbers of school districts that this is true. So that's part of the bill, is to find out. Let's just get the facts. That's all we're asking.
I was really wondering if you had an analysis of prior ones, because we don't usually not long enough, around long enough. I know that in the district I sit on as a chair, we had done quite a bit of research, and we agreed to do this. Why? None of us felt that anyone overruled the rights. So I'm not truly understanding the part that it was done secretively with us.
Well, okay, thank you. You know what? I can't speak to what you experienced. I can speak to what I experienced. I can speak to what my husband has experienced. I can speak to you what many constituents in my 3 communities have experienced, and well beyond as well. What has happened with this. At very best, this has been murky, and we can do better. And as legislators, we should be doing that. As far as the No Child Left Behind, I do know that there are people behind me that have been for years very thoughtfully following that, and perhaps that question could be answered by someone who has more information for you on that.
Thank you.
Thank you.
Mr. Fraser, did you, Representative Weiler, did you have your hand up?
Thank you, Madam Chair. Thank you for taking my question. Did I hear you correctly to say that the Common Core is a federal program out of the Federal Department of Education?
Yes, this is one of the, thank you for the question.
Is the answer yes?
In my opinion, yes.
Okay, thank you, that's all I need.
Okay, thank you.
Representative Fraser, did you want to ask a question? Seeing no more questions, thank you for your testimony.
Thank you, Madam Chair.
And the chair will recognize Michelle Lavelle.
Good afternoon, my name is Michelle Lavelle. I represent the New Hampshire Liberty Alliance. My intention is to address one of the segments of this bill, Roman numeral 2, Part E, where it speaks to the school districts being required to give federal Department of Education unrestricted access to private student data under the cooperative agreement between the United States DOE and the Smarter Balance Assessment Consortium.
Excuse me, Mr. Bell, what line?
I don't have the printed version that you have. I have the one that was available on.
I think it's 25.
Page 2, line 25.
Thank you. So my comments will be limited to the data collection and privacy concerns that the DOE has opened up for all of our students in the state by agreeing to the Smarter Balance assessment test that is required for all public schools. I have a copy, and I will pass this forward. It's a copy of the cooperative agreement that was made between the United States Department of Education, the Smarter Balance Assessment Consortium, and all of the states that will be participating in the Smarter Balance Assessment. This is available through the U.S. government's website. This is the agreement that New Hampshire has signed on to through the Department of Education. The New Hampshire Department of Education has mandated that all public schools, including charters, will need to fully implement the Smarter Balance Assessment by spring of 2015. And they've already piloted these tests in several school districts across the state as of last winter. That information is available on the New Hampshire DOE's fact page. So that's not a secret. They've already been implementing it. If you look on this cooperative agreement on page 3, item number 5, it says it is establishing the agreement to student level, or in other words, individual data. There is nothing in this cooperative agreement that says that the student data is aggregated. Nothing in the agreement says the student data is aggregated. It is raw individual data. That is repeated on page 11, on item number 3, and item number 5B. And as you continue reading on page 10, item number 6, this cooperative agreement says that the states participating in the Smarter Balance Assessment are required to, quote, provide timely and complete access to any and all data collected at the state level to the federal government. So even if New Hampshire is not giving the data to the federal government, the New Hampshire DOE has authorized the federal government to access whatever data they want, whenever they want it. And this is individual information, not aggregated information. It's in the agreement that the New Hampshire DOE has authorized. So the question then pertains to, what about FERPA, the Family Educational Rights and Privacy Act? That is not the privacy protection that it once was. It is no longer sufficient to provide privacy protections to our students. In 2008, FERPA was expanded to include student officials. That now means contractors, consultants, volunteers, and other parties to whom an educational agency or institution has outsourced institutional services or functions it would otherwise use employees to perform. That is language directly from the FERPA law. So school officials are no longer limited to the principals or state agencies themselves. And further, in 2011, they defined 2 other key terms and expanded those definitions. So educational programs now are no longer limited just to improving educational outcomes, but now educational programs are defined as bullying prevention programs, cybersecurity education, and substance abuse and violence protection, regardless of whether the program is administered by an education agency or institution. So FERPA does no longer protect our students' information to be limited to school bodies. Additionally, in 2011, another key term was changed called authorized representatives. Previously, this was exclusively the entities over which an educational authority had direct control, such as an employee or contractor of that authority. Now, it includes an individual or entity that the educational authorized select as an authorized representative. So they've they can authorize access to whoever they wish it to be given to. So then it brings it down to the state level. A few years ago, the New Hampshire legislative bodies passed the unique pupil identifier as a way to try to protect student privacy here in our state. However, that's not the protection it would seem to be either. I have copies of articles that can show you, even as recently in 1999, 15 years ago, there was a situation in Kentucky where the National Assessment of Educational Progress, that NAEP scores, was able to go into that data and use just 7 data points to correctly identify 86% of the actual individuals in their test scores. That was in 1999. In 2009, different computer experts have said all that is needed now are 3 data points to recognize who an individual's scores belong to. There is no such thing as completely anonymizing data anymore. That data can be completely reconstructed. So the unique pupil identifier is not a protection of our students' privacy. And I believe this agreement that the New Hampshire DOE entered into is jeopardizing our student privacy, and it puts every single public school student's information at risk.
Thank you for your testimony. Questions? Seeing none, again, thank you for your testimony.
Thank you.
I would remind members who wish to speak that when you indicate on the card that you want a minute or 3 minutes or so, in view of the number of people who wish to speak, I'm going to hold you to that period of time. We have 2 more bills that we have to hear this afternoon. Excuse me. So I would also ask you if what you were planning to say has already been included in testimony, I would ask you please not to repeat it. With that, I will recognize Deborah Olstra to speak in support of the bill. Welcome to the House Education Committee. I'm sorry.
Thank you. Madam Chair and members of the committee, I am in support of HB 1397, establishing a committee to study whether the Department of Education is operating within its statutory authority. I'm Deborah Oster. I live in Manchester, and I'm here to support the bill. The New Hampshire Department of Education has demonstrated a lack of concern for the transparency to the public. I now attend most state board meetings because there is no other way for me to find out what is happening in the department or on the board without attending each and every single meeting. I bring equipment to videotape the meetings in order to share them with my friends and neighbors. The department also videotapes each board meeting but hasn't posted a single video recording in nearly 2 years. Since May of 2012. In fact, the department just removed a year's worth of agendas and abridged minutes this month, eliminating all of 2010 and replacing it with 1 month of 2014. There are no archived information beyond 2011. That's barely 3 years worth of agendas and minutes that are available. Their minutes, by the way, are abridged and lack any detail. This is unacceptable, given the enormous changes that are occurring within the department and the Board of Education. How can parents and taxpayers begin to understand the motivation behind these changes if there's no record of any public or board discussion, which is readily available for all to review and inspect? Which should be readily available. When the recent ED 306 minimum standards were adopted, the public was told that all the public testimony would be made available on the department website. Many people testified in various locations around the state. the board travels each month. Yet none of these were ever posted to the department website as promised. These changes affect our schools, yet parents and taxpayers are unable to find any of these records either. This lack of transparency undermines our ability to participate in our local and state governments. So please pass HB 1397 and help bring the department back in line with what is good and proper for the citizens of New Hampshire as well as lawful.
Thank you for your testimony.
Appreciate it, thank you.
Questions for Ms. Olson? Seeing none, thank you again.
Thank you.
The chair recognizes Doris Hohensee, sorry.
Good afternoon, my name is Doris Hohensee. I'm here to represent New Hampshire Families for Education. Do you have testimony? Under state law, the curriculum frameworks serve as a guide and a reference. They're not a requirement to be imposed upon districts, as in 193E5. So the Common Core is voluntary, but the department is not going by that. In 2010, the commissioner, anticipating the adoption of Common Core state standards by the board the following month, promised the U.S. Department in the Race to the Top grant application that every district would adopt Common Core state standards. Keep in mind these standards weren't even written at this point, but it's in violation of state law to make that promise. And again, in 2012, the commissioner promised the state, U.S. Department of Ed, under the flexibility waiver, that they would, every district would not only adopt math and English language arts, but also the science and social studies standards by 2014. And if you go to their application itself in the New Hampshire flexibility waiver, this is where they talk about how they're rolling it out in 3 stages: early adopters, middle adopters, and the third and final cohort. This is on page 166. So it's not my imagination. They made these promises. In 2013, in this building, the commissioner told the legislators that Common Core state standards are not voluntary, they're mandatory. Later, the commissioner told us in Bedford that the board never adopted Common Core state standards, they only endorsed them. So the commissioner shouldn't be misleading legislators or the public or the school boards. They shouldn't be mandating Common Core, they're voluntary frameworks. And they have no authority to promise the US DOE, even in exchange for money, that they can override state law. So how did those standards get in our district? That's the next big question. And for page 31 of this same grant application, they talk about the 5 regional liaisons, the newest addition to the support and outreach for the implementing of Common Core state standards. These regional liaisons participate in monthly superintendent, principal, and curriculum and instruction assessment meetings that take place in the respective districts. They also meet bi-monthly with the department. This is not transparent. There are no minutes. They are meeting with my district, outside of my purview. That is my assertion. And they're operating under this division of instruction, which, as the sponsor said, is not even in state law. There are 4 divisions, and all I can surmise is the Division of Educational Improvement was jettisoned somewhere back in the 70s from what little research I can find, and they replaced it with the Division of Instruction. You go on the website, that's what seems to have happened, but they're not a legislative body. How did that happen? Then if you go to the web, and I searched and searched, and I finally found these regional support centers, and it says they're under the DOE, the Division of Instruction, the Office of Educational Technology centers, and then they give the 6 different regional centers that are meeting. They're liaisons. According to this application, they're meeting with my district. And that's what they're tasked. If you go to the department, you look at their tasks, they're tasked to do that. But nowhere in statute were they given this authority. Federally funded, okay, they usurp our state and our U.S. Constitution, particularly Article 4, Section 4 says the United States shall guarantee that every state of the union shall have a Republican form of government. This top-down, no representative, it's education without representation, that's not right. The commissioner is imposing the smarter balance assessments upon the districts, even though they violate the law, RSA 193C, which requires that the assessments be valid and objectively scored. As to valid, if you go to the Smarter Balance website, and you look at their graphs, they have, I put it in my testimony, they say that they are not valid in 2015. They may be verified the following year, but they are not valid according to their own website. So why are we doing things that are in violation of state law? They also have to be objectively scored. But Smarter Balance website, or Smarter Balance assessments include dispositional questions, which was the controversy with Senate Bill 48 last year. We removed that, we don't want that. I asked the board last month how they were gonna remove those dispositional questions that our legislature said no to. Some of the members of the board didn't know what a dispositional question was. It's very disheartening. And again, it's the transparency. They don't have the transparency if they're a new board member to what happened in 2010. She asked, could I bring them the dispositional questions? Well, if they followed RSA 193C10, I would have the right to review and inspect, but I don't. So I couldn't bring them to her either. This is all acknowledged on their website. So I would like you to work with us and have a study committee, and there are many other things that are wrong, and to figure out how to get us back on track of following the law and getting a representative form of government for our people and our schools. Thank you.
Questions for Ms. Holden, please? Seeing none, thank you for your testimony. The chair recognizes Bonnie Dunham.
Thank you. My name is Bonnie Dunham, and I'm speaking as a private citizen. I live in Merrimack, New Hampshire. I'm a parent of four children, one of whom benefited from special education. And I've had the opportunity to work with the State Department of Education on a number of occasions. I am here today opposed to this bill. It seems that it has a tone, one that infers that someone is doing something wrong, and that what's going wrong has to do with the ESEA, the Common Core Standards, the New Hampshire Department of Education, and the State Board of Education. If there's a little trust in the New Hampshire Department of Education and State Board of Education, as this bill seems to indicate, then we have a huge problem, one that I don't even think this committee is prepared to solve. Fortunately, I don't believe that's the case. I believe that mistrust is not only misplaced, but extremely limited and without basis. Many of the questions raised in this bill, who did what, when did they do it, and how, do not require a study committee. They just require someone picking up the phone, calling the Department of Education and asking them the question. Or asking at the State Board of Education. They have public comment at the beginning and at the end of their meetings. My experience with the Department of Education and State Board of Education is that they are extremely receptive and open to public input, more than any other state that I know. When New Hampshire held the State Board of Education had public hearings on some changes to our special education rules, just asking them to led to them holding 5 different hearings in 3 different parts of the state. Whereas in states like New Jersey, they had one at 10 o'clock in the morning in the middle of the state. And so they really do seem to try to find ways to make it possible for anyone who wants to participate to do so. Therefore, since I believe that you have better things to do with your time, not that I'm in charge of your time, except for those few minutes when I'm here, I ask that you please vote to kill this bill. I think of it as essentially a search and destroy mission, and it doesn't seem like that's something that is in the best interest of this committee or this state. Thank you.
Thank you for your testimony, Bonnie Dunham.
Oh, happy to answer
Questions?
questions.
Any questions? Thank you again. The chair recognizes Anne Marie Banfield.
She had to leave. Oh. Emery had to leave.
Anne Marie Banfield. She had to leave.
Yes.
Then the chair will recognize Heather Gage.
Good afternoon. Thank you for allowing me to testify today.
I certainly understand the need of these supporters of this bill to ensure that the Department of Education is being transparent, is offering the opportunity at all times for the citizenry of this state to offer their advice, opinions, and guidance into the work that we do. That's why we're there to serve. I hope that after I go through this testimony, you'll ask us questions that even if I can't answer them, that I can get back to you on to make sure that we're doing the right things by the state. And for the record, my name is Heather Gage. I am actually the division director of the Division of Educational Improvement, which we'll talk about in just a moment. So I'm here to testify in opposition to HB 1397 and to provide additional information to the committee as you consider this bill. By state law, the New Hampshire Department of Education has a dual role of providing regulatory direction and instructional assistance to public elementary and secondary schools, with our goal being to ensure that all school-aged children in the state are provided an adequate education. We believe our mission is to provide leadership and support to educational stakeholders in order to ensure every student acquires the skills and knowledge to succeed in a competitive global economy and thrive as 21st century citizens. This general court has provided focus areas of responsibilities for the New Hampshire Department of Education through its various divisions. One of those, coded in RSA 21N6, which has been already discussed, is the Division of Educational Improvement. I am currently, as I mentioned, the director of this division, and just as the law describes, the following areas are a few of our areas of focus: providing technical assistance and consulting services in both academic and support areas to public education, administering provisions in the law related to special education, administering federal and state programs designed to assist the education of students and teachers, and administering standards for approving elementary and secondary schools, to name a few. This bill implies that the division has eliminated, this division has been eliminated. However, all that has happened over several years is that the New Hampshire Department of Education operationally often refers it to the Division of Instruction. And that's through various conversations with the field from time to time about what is your focus area, and it's about improving instruction for kids in a variety of ways that I just described. All of the intent in the law is intact, and we take the responsibilities and implementation of this law and every law very seriously. Next, the bill implies that the division, quote, oversees 5 regional professional development centers. This is not true, and to my knowledge has never been true. And you'll forgive me if there's any ignorance in that statement, but it's never been true. Some of the PD centers began in order to provide technical assistance in the area of technology. This was back in the 1990s, I believe. And they were actually called tech centers. Federal Title IID funds help school districts in various regions of the state begin to offer regional support around the area of technology through these funds. However, it is important to note that some PD centers have been around for a long time, such as the one in the North Country, which began, I believe, in the 1960s. The oversight from the state has only been in the area of monitoring financial funds that were provided in grant forms to the PD centers through the local school districts based on their requests. Many school districts opt to participate in opportunities from their local PD centers, which provide them with the networking resources from other educators. Educators determine what they want their PD centers to focus on, and if available, can and will apply for allowable funds through the New Hampshire Department of Ed to help them obtain professional learning opportunities. They also apply for grants not associated with the Department of Education. However, they are not, and please let me repeat, they are not commissioned by the New Hampshire Department of Education to provide direction to school districts to implement Common Core state standards or to remediate school, which is referred to later on in the bill. They have, at their discretion and requests from school districts, provided opportunities for educators wanting to learn more about the standards and instructional and improvement activities or strategies, just like they have in the past with other standards or prior to the flexibility waiver. School districts are always allowed to request funds from the DOE for learning opportunities, and God willing, if we have them, we want to make sure that they get in the right hands of districts.
And those funds can be pooled regionally to serve their needs as long as it is an allowable program or project. So now let's talk about regional liaisons that are working with the DOE, going on its second year. Our 5 regional liaisons are former educators who are tasked with assisting the department in understanding the needs of local districts and schools and providing technical assistance when requested. The most important part of what I just described, again, is when requested. The liaisons do attend regional superintendent, CIA, or curriculum instruction and assessment, principal, and other meetings at the request of participants to help us ensure transparent communication to the field. These meetings are not directed by the New Hampshire Department of Education at all. These meetings are driven and facilitated by educators in the schools and districts. The liaisons we have contracted with have many high quality skills, including those in the instructional area. However, they are not and have never been directed to force the implementation of Common Core standards or anything for that matter. They serve as communication assistants between the department and the field as requested by the field. Let me also be clear. The state flexibility waiver does not assure that every school district will implement the Common Core standards as described in 2A on page 3 of the bill. In fact, the page reference in the bill is 166 on this matter, and the waiver only goes to 126. Thank goodness. However, we do agree that the law states that standards will serve as a guide and a reference to what New Hampshire students should know and be able to do in each area of education, and we articulate that in almost every meeting we ever attend, in almost every opportunity we have. Let me be clear. New Hampshire Department of Education does not require local school districts to adopt or implement the Common Core state standards. The state is required to have standards, and we have chosen through what we felt was a transparent process to adopt the Common Core standards for mathematics and English language arts. The same section of the RSA also states that the General Court requires the State Board of Education and the Department of Education to institute procedures for maintaining, updating, improving, and refining curriculum frameworks for each area of education, such as mathematics and ELA, or English language arts. The state's flexibility waiver does not establish a new governance structure, as the bill describes, over existing school districts, but rather allows us, as the Department of Education, to focus additional supports on those schools that are receiving Title I dollars and who we believe have the greatest challenges. Regarding the release of assessment data, and Ms. Levine, if I can talk behind me for just one moment, I would love to have conversations with anyone who has concerns about privacy. And I have not had that conversation with Ms. Levine at this point. I have a copy of a letter that I will send around, recently sent to Secretary Duncan, reiterating our state's and many states' commitment to not sharing personally identifiable information with the U.S. Department of Education. However, it is important to note that this kind of information has never been requested from the U.S. Department of Education. We do share aggregate assessment results as long as it doesn't go below a certain N size or a certain number of students that could be personally identifiable, such as how many students were proficient at the 3rd grade. Nothing in our agreement with the U.S. Department of Education or Smarter Balance requires the release of personally identifiable information. We take student privacy very seriously and have worked diligently with Representative Kirk, which I'm assuming we'll hear that bill soon, to ensure that we are doing all that we can to make sure that our student identity is protected. That is a very, very serious concern of ours, and we are certainly taking that seriously. There was a reference to the agreement with Smarter Balance, and if you will look at a footnote that is attached to a section that was described, it says that this does not supersede state law. And our state law has and will continue to protect student privacy, given your guidance in that area. So that is all that I have. I'm sure that there are questions that I would love to take at your discretion.
First of all, do you have written testimony?
I do, and I just noticed a couple typos, but I'm happy to pass that on.
And the rest of the members of the committee would appreciate your testimony. Thank you very much.
I do have one copy, but I'm happy to email the rest of the committee.
Very thorough and detailed. Representative Vick, you have your hand up.
Yes, thank you, Madam Chairman. In light of what you just said, my background was basically with the federal government, and I constantly was being reviewed by an internal audit division or by the Office of Personnel Management. Based on what you said and the other testimony, is there any organization within the Department of Education or within the state that reviews your procedures and makes sure you're following the appropriate law, rules, and regulations?
Absolutely, we have an internal audit division, and we actually are probably on a weekly basis audited in some program from external sources.
And copies of this would be available?
Of course.
Seeing no further questions? Oh, I'm sorry. Representative Myler.
Sorry, Madam Chair.
We might as well resign ourselves to being here for the rest of the afternoon.
The issue of privacy is a key issue.
I believe so too.
And if I understand your testimony, you said that the department has a kind of an ironclad policy that deals with aggregate information that does not provide any opportunity to get individual information on student results. Is that correct?
Correct. We have a state policy that this general court has designed, and we follow that very, very closely, as well as internal procedures.
I follow. Isn't it true that the consortium that deals with the Smarter Balance has also developed a policy that deals with the issue of privacy that basically says they don't want individual information, only aggregate information?
That is correct, and I'm happy to provide a policy statement to the committee.
Thank you.
And I will pass out, this is the letter that we have sent to Secretary Duncan regarding that. And I do have copies of that.
Further questions? Seeing none, thank you for your testimony. And the chair will recognize Anthony, is it Nino? From Amherst. Welcome to House.
Pardon?
Welcome to House Education Committee.
Oh, it's such a beautiful day with cool breeze running through the streets. My name's Anthony Nino. I'm from Amherst, New Hampshire. I served 8 years in the Air Force. I was a security policeman. And afterwards, when I got out of service, I was an automotive technician and I'm retired. Now, there's been a lot of good testimony. For pro, Common Core, for pro, what is being done, transparency. But when I saw this bill, something came up to mind, and that was accountability and how much Americans really trust their government. Now, I'm not going to sit here and say anyone has done something wrong, and I'm not going to say that someone has necessarily done something right. I have sat in no Department of Education meetings, and I'll tell you, I trust those in those proceedings to do what is right. Back in, let's see, Gallup poll 5392 in September, last September, shows that 81% of Americans do not trust their government to do what is right. I thought it was going to be around 60% when I was looking it up on their website. And I think what this shows is that through transparency and oversight, we can do a lot to restore public confidence in what is going on up here in Concord, and also what is going on in Washington. One of my favorite sayings as a security policeman, when someone would have an accusation, I would say, can you prove it? Pro or con, can you prove it? And if they thought they could, I'd say, okay, let's start an investigation. Let's have some oversight here. And so that's what I say here. I do believe this bill is going to establish essentially an investigative committee. Is that correct?
The proposal is to establish a committee, a study committee, yes.
I'm all for that. And if the results show pro and if the results show con, then let's show the results. And let's help restore some public confidence in the proceedings that go on. Does anyone have any questions?
Thank you for your testimony. Does anyone have any questions for Mr. Nino? Seeing none, thank you.
Well, I would like to add one other thing also. In the service, We are constantly evaluated. There's oversight at every level. There was a squadron, there was a wing, there was a command, and an Air Force inspection every year. And as an auto mechanic, when I worked at a Jeep dealership down in Nashua, every year we had the boys from Detroit, as we say, come in with clipboards. And they would stand there and watch us repair customers' cars, and we had no problem with it. Thank you very much.
The chair will recognize Rosemary Landry. Good afternoon.
Good afternoon.
Welcome to House Education.
I'm sorry?
Welcome to House Education.
Oh, thank you. Honorable Chairman and committee members, my name is Rosemary Landry, and I'm from Meredith, New Hampshire. And I have 3 children. They live in different states, Maine, Florida, and down in Cape Cod. And I have 11 grandchildren. And my 3 children have very high concerns about this Common Core and the standards that they have in the different states. They're called different things in different states. And so that naturally made me concerned. And I've been going to a lot of meetings about Common Core, and I am very concerned. A lot of my friends are concerned because for instance, I have a friend in Windham, and he was telling me that in the schools, they have somebody who comes into the classrooms and checks the teachers to make sure they're teaching the Common Core standards properly. So, you know, that's a concern for me. And last summer, I went to my first Department of Education meeting here in Concord. And I sat and I listened to everybody, and then at the end of the meeting, I went up. There was, I forget who, Board of Education, I forget who it was, and I said to a gentleman there, I said, well, what about the parents? Don't they have a say in this? And he looked at me and he said no. And so I think the parents are left out of this whole situation, and it's a real concern for me, for all my grandchildren, you know, to make sure they have a good education, just like my children did. I also want to say that I went over about the meetings. I want to say that the parents are bypassed in this whole process, that they should be included in anything that has to do with education. I know there's board members with high education and everything, but they need to have parents on these boards so that they will be able to express their concerns. So I am for this bill, and I think that we need a study, and I also have a young lady stated from the educational department that they have people who check, you know, what they're doing and everything, but it never hurts to have another check, and I think that's what's needed. Thank you very much.
Thank you for your testimony. Questions for Mrs.
Oh, I'm sorry.
Condon? Seeing none, thank you again.
You're welcome.
And I will close the hearing on House Bill 1397. And in 2 minutes, I will open the hearing on House Bill 1445.
I'll put in. Thank you, Madam Chair, and thank you to the Education Committee. Yeah, I'm a co-sponsor on this bill, but I think everybody's missing the point on the question. The school district, the sending school district, has budgeted money, we'll say, for 50 kids to go to this school district. They don't have a school. So maybe 5 of those kids are going to go to a charter school. That sending school district now has a windfall of 5 kids' tuition that they don't have to spend. And I think that's a point, because here they budgeted for 50, they're only spending 45, and So what are they gonna do? They're gonna probably try to get all their kids to go to a charter school. Then they don't have to spend anything. So what's fair is fair.
Representative Grassi has a question for you, Representative Bone.
Thank you.
Once a school district has settled a budget, say for 50 kids, there's nothing to say that 10 more kids won't move into that district or 10 kids move out of the district. Either way, you're either facing a shortage or a windfall. Either way. So I think that your argument about sending 5 kids to a charter school, you know, those things happen in school districts all the time.
Right, but the point is, here, they know, say for example, hey, all these kids are going, they all graduated, say, from the 8th grade of this school, and we know we have 50 kids, and we're gonna budget that much. Yeah, yes, there's always comes and goes and whatnot, but the point is it's still gonna end up being, hey, good, lucky, they're gonna go to charter school, and we don't have to pay for it.
Follow-up?
Is it not true that without this law, they could still pay the charter school?
It's not a private school, it's a charter school.
I didn't say private school.
I thought that's what-
Isn't it true that without this bill, that community could already pay the charter school?
If they budgeted it as such, if they didn't budget it as such, they couldn't.
But they can.
Representative Brenner?
Thank you, Madam Chair, and thank you for taking my question. This is not about the money or money saved, it's purely this concern. If a sending district did send their students to 5 different schools, whatever the agreement, there would be, I believe, a vote by the residents to approve each of those 5 schools. And could you comment on my concern that and it's the one issue I have here, is that this bill now says that if one of them is a charter school, in this particular example, that the voters would vote on the other 4, but would have no say on this bill. Is that how it is, and am I understanding?
Well, I'm going back to my school, but before we had our own high school, we were sending so many kids to Hudson and so many kids to Manchester, and it wasn't an area agreement, it was just a tuition agreement that was done every so many years, and it was basically no less than 75% to Hudson and no more than 25% to Manchester. And they changed depending on what. But we had a lot of kids, so a couple here and there isn't going to matter. But if you have a small number of kids, and most budgets are going to say, be one-line budget saying tuition to high school or whatever, not to in each individual school, it'll be, on the budget will be a total tuition rate, total tuition amount that's going to be paid for tuition. And if some of those kids, 10%, don't go to one of those public schools, they go to a charter school instead, then the budget has got, hey, we got extra money.
I understand that, but the one thing that's just hard for me is if we require the voters, and whether it's a tuition agreement or what kind of agreement, I believe that the district is supposed to have the opportunity, the voters, to approve each of these agreements. Whereas, what I mentioned, if 4 of the schools they vote on, but this exception now, they don't have a right to vote. And that's just my concern. But that's all.
My end of that is this will happen after the fact, after the voting, after the budget's approved.
Thank you for your testimony, and I'm going to close the hearing on House Bill 1393 and open the hearing on House Bill 1397 and recognize Representative Cormier. If he will be kind enough to send up a big